Good morning, everyone. On behalf of Karnataka Judicial Academy, I welcome you all to this second day of Capacity Building Orientation Program on New Criminal Laws 2023. Today, we have with us Shri Madhukar Deshpande, and it is my honor to introduce before you all Shri Madhukar Deshpande, a highly accomplished legal professional with a distinguished career spanning over 2 decades. Sir completed an LLB from ILS Law College Pune in 2000 and went on to earn an LLM from University Law College Bengaluru. With more than 20 years of practice experience, Sir has represented clients before the High Court of Karnataka, various tribunals and authorities specializing in writs, constitutional matters, service law, civil and criminal law, commercial law and economic offences. Since 2015, as per the orders from the Government of India, Sir has served as a senior panel counsel representing the Union of India before the High Court of Karnataka. In addition, from 2021, Sir has been representing the Registrar General, High Court Legal Section and High Court of Karnataka. Sir is also on the panel of several esteemed organizations including the State Bank of India, Directorate of Enforcement, Agricultural Produce Marketing Committee, Government of Karnataka, Indian Space Research Organization, Raman Research Institute, Indian Statistical Institute, Baba Atomic Research Center, Southwestern Railways, and the Serious Fraud Investigation Office. From 2003 to 2015, Sir served as a guest faculty member at University Law College, Sheshadripuram Law College, CMR Law College, and Kaili Law College. Since 2010, Sir has been associated with the Karnataka State Bar Council, conducting law workshops across Karnataka for advocates. Additionally, Sir collaborates with the Bengaluru Advocate Association and other associations to provide training and classes for advocates. Sir has domain expertise in handling economic offences, which include a wide range of crimes occurring during economic or business activities, such as tax evasion, trafficking, smuggling, money laundering. Sir has conducted cases related to economic offences in both High Court and trial courts. Notably, Sir has significant experience with the Narcotic Drugs and NDPS Act and the Prevention of Money Laundering Act, serving as a panel advocate for Enforcement Director and appearing for the prosecution at various stages. Sir, I on behalf of Karnataka Judicial Academy and behalf of all the attendees present here, welcome you to this session. I request Sir to address the officers on new dimension in assessing the relevancy of facts, primary and secondary evidence, oral evidence, and other allied reforms, analysis of electronic evidence and its admissibility under Bharatiya Sakshi Adhiniyama with special reference to Arjun Pandit Kotkar. Over to you, sir. Thank you.
Thank you, madam. Thank you, madam. Thank you, madam. Thanks for introducing me to this August gathering. Of course, there is a need of introduction, but ನಿಮ್ಮ ಒಂದು ಪರಿಚಯ ನನಗಾಗಿ ಅವಶ್ಯಕತೆ ಇಲ್ಲ, ಯಾಕಂದರೆ ನಿಮ್ಮೆಲ್ಲರ ಮುಂದೆ ನಾನು ಅಪಿಯರ್ ಆಗಿದ್ದೀನಿ. ನನ್ನ ವೃತ್ತಿ ಜೀವನ ನಿಮ್ಮ ಮುಂದೆ ಪ್ರಾರಂಭ ಮಾಡಿದ್ದೀನಿ, ಹಲವಾರು ನ್ಯಾಯಾಧೀಶರ ಮುಂದೆ ನಾನು ಪ್ರಾರಂಭ ಮಾಡಿದ್ದೀನಿ. ನನ್ನ ಹಲವಾರು ಮಿತ್ರರು ವಕೀಲ ಮಿತ್ರರು ನ್ಯಾಯಾಧೀಶರಲ್ಲಿದ್ದೀರಿ. ನನ್ನ ಮೆಚ್ಚಿನ ವಿದ್ಯಾರ್ಥಿ ವಕೀಲರಾಗಿ ಆಮೇಲೆ ನ್ಯಾಯಾಧೀಶರಾದವರು ಸಹ ಇಲ್ಲಿದ್ದೀರಿ. ಇಂತಹ ಒಂದು ಸನ್ನಿವೇಶದಲ್ಲಿ ಕನ್ನಡದಲ್ಲಿ ಹೇಳೋದಕ್ಕೆ ಬಹಳ ಖುಷಿ ಅನಿಸುತ್ತೆ, ಯಾಕಂದರೆ ನನ್ನ ಭಾವ ಏನಿದೆ, ನನಗೇನು ಅನಿಸುತ್ತೆ ಅದನ್ನು ಬಹಳ ಖುಷಿಯಿಂದ ಹೇಳೋಕ್ಕೆ ಅವಕಾಶ ಇದೆ. Once again, thanks for introducing me and giving an opportunity to interact with you all. I should be thankful to this particular legislation, because of this particular legislation, which is coming into effect on 1st July 2024. I am here, and that is the reason I am addressing you people. The subject which has been given to me is a very interesting subject. that is Bharatiya Saksha Adhiniyama. It is coming into effect from 1st July 2024. Earlier to this particular legislation, even today also we have one particular legislation, that is Indian Evidence Act 1872. Earlier to 1872, what was the situation we need to understand so that we can understand this particular legislation in a better fashion. Earlier to 1872, there was no written law, and on the basis of human memory, the cases were decided. Of course, before an arbitrator or before a head of a village, he used to decide the cases. He used to administer the justice and decide the cases. At that point of time, it is only human memory. I'm just talking about the simple word. The life was very simple. So the human memory was the source of information. That particular person who is a godly fearing, he used to appear, and the weightage used to be attached to his statement. On that basis, the cases used to be decided. That was the world, a simple world. At that point of time, there was no document because printing technology had not developed. Typewriter was not there. Of course, computer was not there. So it was only the human memory, the basis, human memory was the basis to decide the cases. As there was change in the technology, or as the technology advanced, the print technology as well as documentation, when it started, as the civilization developed, and documentation is the one aspect which is one of the development of the part of the civilization, the rules relating to the evidence also changed. The main object of the law of evidence is best evidence. Best piece of evidence should be produced before the court. As the documentation started, preparation of the documentation became easier. Printing technology developed. Because of those development, the credence was given to the document. The principle developed. One principle developed, that is, if there is a document, exclude the oral evidence. These two aspects are taken into consideration. In the year 1872, one first legislation was legislated, that is Indian Evidence Act. In that particular legislation, two types of evidence are recognized. One is oral evidence, we all are aware of it. That is a statement made by a person before the court. That particular statement would be received by the court, and that is considered as a oral evidence. We all are aware of it. The second category is documentary evidence. These are the two categories which are recognized. What is the interplay between the oral evidence and documentary evidence? All those things are considered in this Indian Evidence Act, and Indian Evidence Act address all these issues. This was exactly 152 years back. The Indian Evidence Act had come into effect on 1st July 1872, exactly 152 years back. Now we have another legislation, and it is coming into effect on 1st July 2024. Between 1872 and 2023 or 2024, there is lot of changes have taken place. Technological advancement have taken place. Because of this change in the technology, there is a need to change the Indian Evidence Act, and that is the reason why this new piece of legislation has been given to the people of India. That is what we need to understand. And there are two other legislation. Of course, I am not going to touch those legislation, but peripheral area of those legislation also I will touch to understand this particular legislation. 1872 was a period we need to visualize how was that particular period, what was the importance of an oral evidence, what was the import of documentary evidence, and then we can understand how that particular legislation was given effect, how that particular legislation was used for deciding the cases. Now there is a sea change. There are many other technical advancement has taken place. That has been addressed in this particular legislation. After 1872, there are several amendments have taken place with respect of that particular legislation, that is Indian Evidence Act. One more amendment has taken place in the year 2000. That particular amendment is also very important. That particular amendment introduced the concept of electronic evidence. That particular electronic evidence, which was introduced in the year 2000, has taken care of Information Technology Act, information which are available in the technical form, and that is also considered as another form of evidence. After 2000, whether there is a need of one more legislation is the question. Some of the statements, some of the legal jurists have taken a view that this particular, the earlier act, that is 1872 act, is reiteration and there is no change in the new law. That is one version. And I am of the view that there is a sea change. There are so many interesting aspects available in this particular legislation. No doubt, new concepts have not been introduced. But the way in which we need to appreciate the evidence, the way in which we need to receive the evidence, admissibility, there is a change in that. There are so many interesting aspects are there, which I am going to explain it. But I want to inform you one thing, that is, I am an advocate. I am not a judicially trained person. A judicially trained person, he will take a particular view as per the law, as well as per the judgment rendered by the Supreme Court or the High Court. But I am the person, I have a privilege to criticize the law, to criticize the judgment also. I am also entitled to take extreme views also. If I am taking an extreme views with respect of any of the provisions of this act, or extremely glorifying the provisions, or extremely criticizing some of the provisions of this particular act, please pardon me. I am entitled to take that. ಕೋರ್ಟ್ನಲ್ಲಿ ನಮ್ಗೆ ಸಿಕ್ಕಾಗ ನಾನು ಕೇಳ್ತಾ ಇರ್ತೀನಿ ಏನು ಅಂತಂತಂದರೆ, ಪ್ರತಿಯೊಂದು ಕೇಸ್ನಲ್ಲೂ ಸಹ ಅಫ್ಕೋರ್ಸ್ ಸೀನಿಯರ್ ಅಡ್ವೊಕೇಟ್ಸು ಸಹ ಲಾ ಏನನ್ನೋದು ಗೊತ್ತಿರುತ್ತೆ, ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ಜಜ್ಮೆಂಟ್ ಏನಿದೆ ಅಂತ ಅನ್ನೋದು ಗೊತ್ತಿರುತ್ತೆ. ಆದರೆ ನಾವು ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡ್ತೀವಿ ಏನು ಅಂತಂದರೆ, ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ಜಜ್ಮೆಂಟ್ ನಮ್ಮ ವಿರುದ್ಧ ಇದ್ರೂ ಸಹ ಆ ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ಜಜ್ಮೆಂಟಿನ ವಿರುದ್ಧವಾಗಿ ಈ ರೀತಿ ನಮ್ಮ ಆರ್ಗ್ಯುಮೆಂಟು, ದಿಸ್ ಈಸ್ ಮೈ ಕಂಟೆನ್ಷನ್, ದಿಸ್ ಈಸ್ ಹೌ ವಿ ಆರ್ಗ್ಯೂ. In one particular case, in one particular area of law, a designated senior advocate used to appear on regular basis, and he used to argue diagonally contrary to the law of the Supreme Court. And at the end of the day, that particular, the case used to be decided in favor of the prosecution and against the defense, on whose behalf the learned senior counsel was appearing. After 3-4 months, when there was around 20-22 cases were decided as per the judgment of the Supreme Court, I personally met the learned senior advocate. Sir, why you repeatedly argue that particular point? You can argue on any other point. You cannot argue against the judgment of the Supreme Court. Then he gave a piece of advice to me. I argue on behalf of my client. I have a duty towards him. At the same time, I have a duty towards the profession. I argue hoping that one day the court will accept my submission and subscribe my views. And it happened. The submission, what the learned senior advocate used to argue on every day, on every occasion, that was subscribed by the Supreme Court by a full court and full bench, and the law was toppled. I am entitled to take that extreme views, and I am entitled to commit the mistake also, but you are not entitled to commit the mistake. ಕೋರ್ಟ್ನಲ್ಲಿ ಏನು ಅಂತಂತಂದರೆ ಎಲ್ಲರ ನಡುವೆ ಜಿಜ್ಞಾಸೆ ನಡೀತಾ ಇದೆ, ಏನಪ್ಪ ಇದು ಹೊಸ ಲಾ ಬಂತು ಹೇಗೆ ಅಂಥೇಳಿ ಅಂತ. ನಾವು ವಕೀಲರು ಹೇಗೆ ಅಂತಂದರೆ ಲೈಟರ್ ವೇನ್ ಹೇಳ್ತಾ ಇದ್ದೀನಿ. ನಮಗೆ ಇದ್ರದ್ದು ಇಫೆಕ್ಟ್ ಯಾವಾಗಿಂದ ಬರೋಕ್ಕೆ ಸ್ಟಾರ್ಟ್ ಆಗುತ್ತೆ ಅಂತಂದರೆ 1 ಜುಲೈಯಿಂದನೇ. ನಾವು ಕಾನೂನನ್ನು ಪುಸ್ತಕ ತಿರುಗೋದು ಯಾವಾಗ ಅಂತಂದರೆ ಕ್ರಿಮಿನಲ್ ಪ್ರೊಸೀಜರ್ ಕೋಡ್ ಹೊಸದು ಯಾವಾಗ ಅಂತಂದರೆ ಬೇಲ್ ಪಿಟಿಷನ್ ಹಾಕಬೇಕಾದ್ರೆ ಯಾವ ಸೆಕ್ಷನ್ನು ಅಂತ. ಯಾಕಂದರೆ ಅವತ್ತಿನ ದಿವಸ ನಮಗೆ ಫೀಸ್ ಬರುತ್ತೆ, ಅಲ್ಲಿವರೆಗೂ ನಾವು ನೋಡಲ್ಲ. ಭಾಳ ಇಂಟ್ರೆಸ್ಟಿಂಗ್ ಏನು ಅಂತಂತಂದರೆ ನಮ್ಮ ಎಲ್ರಿಗಿಂತ ಜಾಸ್ತಿ ಕೌತುಕವಾಗಿ ಯಾರು ಕಾಯ್ತಿದ್ದಾರೆ ಅಂತಂತಂದರೆ ಪೊಲೀಸ್ ಆಫೀಸರ್ಸ್ಗಳು. ಪರ್ಟಿಕ್ಯುಲರ್ಲಿ ಈ ಪೊಲೀಸ್ ಸ್ಟೇಷನ್ನಲ್ಲಿ ರೈಟರ್ ಇರ್ತಾರಲ್ಲ ಅವ್ರಿಗೆ ನಾನು ಪ್ರಶ್ನೆ ಕೇಳ್ತಿರ್ತೀನಿ. ನಮಗೆ ವಿ ಗೆಟ್ ಅಪಾರ್ಚುನಿಟಿ. ಸೊ ನಾನು ಅವ್ರಿಗೆ ಪ್ರಶ್ನೆ ಕೇಳ್ತಿರ್ತೀನಿ, ಏನು ರೀ ಹೇಗೆ ಮಾಡ್ತಿದ್ದೀರಾ ಏನು ಅಂತಂದರೆ, ಸರ್ ನಾವು ರೆಡಿ ಆಗಿಬಿಟ್ಟಿದ್ದೀವಿ ಅಂತ. ಹೇಗೆ ರೆಡಿ ಆಗಿದ್ದೀರಾ ಅಂತ ಕೇಳ್ತೀನಿ. ಏನಿಲ್ಲ ಸರ್, ಭಾಳ ಏನು ತೊಂದರೆ ಇಲ್ಲ, ಹೊಸ ಕಾನೂನು ಬರಿತೀವಿ, ಎಲ್ಲ ಕಂಪೇರಿಟಿವ್ ಟೇಬಲ್ ಸಿಕ್ಕಿದೆ, ಹಳೆ ಕಾನೂನು ಬ್ರ್ಯಾಕೆಟ್ನಲ್ಲಿ ಬರೆದು ಬಿಡ್ತೀವಿ, ಸಾಹೇಬ್ರು ಏನು ಡಿಸೈಡ್ ಮಾಡ್ತಾರೆ ಮಾಡಲಿ ಅಂತ. ಸೊ ನಾವು ಸಹ ಅಷ್ಟೇ ಮಾಡ್ತೀವಿ. ಸೆಕ್ಷನ್ ಬರಿತೀವಿ, ಸೆಕ್ಷನ್ ಬರೆದ್ಬಿಟ್ಟು ಬ್ರ್ಯಾಕೆಟ್ನಲ್ಲಿ ಹಳೆ ಸೆಕ್ಷನು ಬರೆದ್ಬಿಡ್ತೀವಿ. ಟ್ಯಾಕ್ಸ್ಮನ್ ಅವ್ರದ್ದು ಕಂಪೇರಿಟಿವ್ ಟೇಬಲ್ ಇದೆ, KLJ ಅವ್ರದ್ದು ಕಂಪೇರಿಟಿವ್ ಟೇಬಲ್ ಇದೆ, ಬಹಳಷ್ಟು ಕಂಪೇರಿಟಿವ್ ಟೇಬಲ್ ಇದೆ. ಆ ಟೇಬಲ್ ನೋಡ್ಕೊಂಡ್ಬಿಟ್ಟು ಬರಿತೀವಿ. ನಮಗೇನು ಅಂಥ ದೊಡ್ಡ ಪ್ರಶ್ನೆ ಇಲ್ಲ. ಬಟ್ ಪ್ರಶ್ನೆ ಬರೋದು ಯಾವಾಗ ಅಂತಂತಂದರೆ 1 ಜುಲೈ ದಿವಸ ಅಥವಾ ಈ ತಿಂಗಳ ಕೊನೆಯ ದಿವಸದ ರಾತ್ರಿ, ಯಾವಾಗ ನಿಮ್ಮ ಮುಂದೆ 12 ಗಂಟೆ ನಂತರ CJM ಮುಂದೆ, ಮ್ಯಾಜಿಸ್ಟ್ರೇಟ್ ಮುಂದೆ ಬಾಗಿಲು ಬಿಡೋದ್ಬಿಟ್ಟು FIR ಪ್ರೆಸೆಂಟ್ ಮಾಡ್ತಾರಲ್ಲ, ಅವತ್ತು ಪ್ರಶ್ನೆ ಇರೋದು. ಫಸ್ಟ್ ಪ್ರಶ್ನೆ ಬರೋದು ನಿಮಗೇನೆ, ಅದನ್ನು ಡಿಸೈಡ್ ಮಾಡಬೇಕಾಗಿರೋದು ನಿಮಗೇನೆ. ನಾನು ಫಾರ್ ಎಕ್ಸಾಂಪಲ್ ಏನಂತಂತಂದರೆ, ಐ ಕೀಪ್ ಡಿಸ್ಕಸಿಂಗ್ ವಿತ್ ಮಿಸಸ್ ಅಮೃತ. ಸತೀಶ್ ಹ್ಯಾಪನ್ಸ್ ಟು ಬಿ ಮೈ ಕ್ಲಾಸ್ಮೇಟ್. ಆಮೇಲೆ ಆಳ್ವಾಜಿ ಮರಾಠೆ ಸಾಹೇಬ್ರ ಜೊತೆಗೆ ನಾನು ಮಾತಾಡ್ತಾ ಇರ್ತೀನಿ. ಸರ್, ದಿಸ್ ಪರ್ಟಿಕ್ಯುಲರ್ ಇಂಟ್ರಾಕ್ಷನ್ ಶುಡ್ ಸ್ಟಾರ್ಟ್ ಆಫ್ಟರ್ 3-4 months ಅಂತ ಹೇಳ್ತೀನಿ. ದ ರೀಸನ್ ಈಸ್ ದ್ಯಾಟ್ ಯು ವುಡ್ ಅಂಡರ್ಸ್ಟ್ಯಾಂಡ್ ಯು ವಿಲ್ ಬಿ ದ ಬೆಸ್ಟ್ ಪರ್ಸನ್ ಟು ಅಂಡರ್ಸ್ಟ್ಯಾಂಡ್ ದಿಸ್ ಪರ್ಟಿಕ್ಯುಲರ್ ಲಾ ಆ್ಯಂಡ್ ಆಲ್ಸೋ ಟು ಅಪ್ಲೈ ದ ಲಾ, ಬಿಕಾಸ್ ಯು ಆರ್ ದ ಫಸ್ಟ್ ಪರ್ಸನ್ ಟು ಡಿಸೈಡ್ ದಿಸ್ ಪರ್ಟಿಕ್ಯುಲರ್ ಲಾ. ನೋಡಿ ಎಂಥ ಅಪಾರ್ಚುನಿಟಿ ನೋಡಿ. 1872 ಇದ್ದದ್ದು 152 ವರ್ಷದಲ್ಲಿ ಎಷ್ಟು ಜನ ಜುಡಿಷಿಯಲ್ ಆಫೀಸರ್ಗಳು ಬಂದು ಹೋಗಿರ್ಬೋದು. ದ್ಯಾಟ್ ಅಪಾರ್ಚುನಿಟಿ, ವಿ ಹ್ಯಾವ್ ಗಾಟ್ ದ್ಯಾಟ್ ಅಪಾರ್ಚುನಿಟಿ ಟು ಡಿಸೈಡ್ ಇಟ್. ನಾನು ಎಲ್ರಿಗೂ ಅದಕ್ಕೆ ಹೇಳ್ತಾ ಇರ್ತೀನಿ, ನಾನು ವೀರೇಶ್ ಆಗಿರ್ಬೋದು ಅಥವಾ ಬೇರೆ ಜುಡಿಷಿಯಲ್ ಆಫೀಸರ್ಸ್, ಯಂಗ್ ಜುಡಿಷಿಯಲ್ ಆಫೀಸರ್ಸ್, ಹೊಸ ಭಾಷೆ ಬರೆಯೋದಕ್ಕೆ ಅವಕಾಶ ಇರೋದು ಇವರಿಗೆಲ್ಲ. ಸೊ ಅಂತಹ ಒಂದು ಕಾನೂನಿದೆ, ಅಂತಹ ಒಂದು ಪೀಸ್ ಆಫ್ ಲೆಜಿಸ್ಲೇಷನ್ ಕೊಟ್ಟಿದ್ದಾರೆ. And I am trying to take extreme views about this particular legislation. This particular legislation, there is a lot of changes have been introduced in this particular legislation, and that particular changes we will try to understand. In this session, I will try to explain what are the structural changes have been made in this particular legislation, and also I will try to explain what is the change with reference to electronic evidence, electronic record. Next slide, okay. Before the year 2000, if anybody wants to produce the electronic record, he was required to produce along with the device. It was a difficult task, and that was the law. So if it is a tape recorded version, then referring to section 7, we used to produce it. It was an uphill task. That was taken into consideration, that particular difficulty was taken into consideration. In tandem with the Information Technology Act 2000, amendment was made to the Indian Evidence Act. First dispensation was, if you want to produce the electronic record, you may dispense with the producing of the device, but you need to attach a certificate under section 65B. That is the first introduction. That is the change which was introduced in the year 2000. So physically bringing the server or physically bringing the computer or physically bringing the apparatus, electronic apparatus was dispensed with, but I was required to comply with the 65B certificate. That particular concept has been retained. It is available in this particular new legislation also. But I am just trying to explain what is the effect in the year 2000, how that particular amendment allowed us to produce the document before you, that particular provision, how it allowed you to receive the evidence and appreciate that particular evidence without producing the actual device. That was one particular change. Then there was a change in the definition of evidence. The definition of evidence which was available in the prior to 2000 and after 2000, there is a change in that. But the definition of document was not altered. Definition of document was not altered, and definition of document has been altered or modified in this particular legislation. Now I will just go back to the new legislation. Next slide. This particular new legislation, there are many objects of this particular legislation. One of the objects is earlier legislation does not address the technological advancement undergone in the country during the last few decades. So few decades means past 2 decades after 2000. Then this particular legislation, that is please next slide. The Indian Evidence Act, earlier we had 3 parts. Now we have 4 parts. That does not mean that there is a new concept or completely new part has been introduced. Earlier part 1 was there. That particular part 1 has been divided into 2 parts. Part 1 comprises of section 1 to 55. That particular part 1, now it has been divided into 2 parts, part 1 and part 2. The part 1 comprises of section 1 and 2, that is preliminary part. Then part 2, relevancy of facts, section 3 to 50. So earlier what was part 1, it has been divided into 2 parts. There is no change. So you can understand, there is no new part has been introduced. So this is the structural change which has been made. The second part, that is on proof, section 56 to 100. Now it is part 3, that is on proof, section 51 to 103. In this part, you can see moderate increase in the number. Only in this part you can see the increase in the number. The increase in the number is with reference to electronic record. Next one is part 3, production and effect of evidence, burden of proof, exclusion of oral evidence, of witnesses, and all other part. That particular section, section 101 to 167, that particular part has been retained as it is. Only thing is that now it is section 104 to 170. So you can see what was earlier, the same concepts are retained in the new legislation also. Next slide, okay. Now, with respect of part 1, chapter 1, that is now part 1, chapter 1 only. Earlier, it comprises of 4 sections. Section 1 is with respect of the legislation which has come into effect and where it is applicable, same concept has been retained and it has been reiterated. Section 2 was repealed in the year 1938. Section 2 of the earlier legislation was repealed in the year 1938. That is now completely obliterated. That is the only change. So section 2 is not available here. There is no need to have that particular section. Section 3 was the interpretation clause. Unlike any other legislation, section 2 is the definition clause. Whereas in Indian Evidence Act, we had a special provision. The section 3 used to deal with the definitions. That particular section 3 is now section 2. Earlier it was interpretation clause, now it is definition clause. Many terms have been defined under section 3, that is court, fact, relevant, fact in issue. The same definitions are available in section 2 also. There is no change. Earlier, we had a dedicated section with respect of may presume, shall presume, and conclusive proof. That is section 4. in our law school, we at 2 times we used to study this presumption. One is under the jurisprudence, under the head of jurisprudence we used to study, and then under the head of law of evidence we used to study the concept of presumption. Only after coming to the, when we started practicing, then we understood where all these presumptions are available. Then we understood the significance of presumption as well as the conclusive proof. So earlier we only used to refer to section 4 and then we used to answer the question in the examination. Now that particular section 4 is completely removed. What is defined, the definition of presumption which is available in section 4, it is now available in section 2. This is one cosmetic change which has taken place in this particular legislation. The next change what we can notice here is, next slide hogi, that is the expression certifying authority, electronic signature certificate, electronic record, those expressions which are available in the Information Technology Act were adopted in the Indian Evidence Act. Now those expressions are also adopted in the new legislation. But there is one particular change. The definitions which are available in the new Indian Penal Code as well as definitions which are available in the new CRPC, that is BNS as well as BNSS, are also adopted in this particular legislation. This is the statement which has been made in this particular legislation. So this is one particular change. So conveniently, we used to argue before you. We used to argue on the basis of various other legislation, either the General Clauses Act or other legislation, minor criminal laws. And with reference to those legislation, the definition which are available in those statute, we used to refer to and then we used to address the argument. Even though those definitions are available in the Indian Penal Code as well as CRPC, we never used to refer. On the basis of our convenience, we used to refer it. Now that has been addressed to the new legislation. What it says that if there is any express definition is available and that particular definition is available in the BNS or BNSS, that particular definition has to be taken into consideration while interpreting the various provisions of the various provisions of BSA. This is one marked change what you can notice. In this definition clause, there are two other changes. The next change is with reference to the evidence. The definition of evidence earlier was like this. The spirit of that particular definition has been retained. I have not, verbatim I have not extracted here so as to understand easily. The earlier definition, all statements which are made before the court by witnesses are called oral evidence. This was the first part of the definition of evidence. So, nudi sakshi anta navu ಏನು ಕರಿತೀವಲ್ಲ ಅದನ್ನ. So, ಒಬ್ಬ ಸಾಕ್ಷಿ ನ್ಯಾಯಾಲಯಕ್ಕೆ ಬರಬೇಕು, ನ್ಯಾಯಾಧೀಶರ ಮುಂದೆ ನಿಂತ್ಕೋಬೇಕು, ಕಟಕಟೆಯೊಳಗಡೆ ಬರಬೇಕು, ಪ್ರಮಾಣ ಮಾಡಬೇಕು, ಆಮೇಲೆ ಅವನ ಹೇಳಿಕೆಯನ್ನು ಕೊಡಬೇಕು. ಆ ಹೇಳಿಕೆಯನ್ನು ರೆಕಾರ್ಡ್ ಮಾಡಿಕೊಳ್ಳೆ ಅದನ್ನು ಒಂದು ನುಡಿ ಸಾಕ್ಷಿ ಅಂತ ನಾವು ಕರಿತೀವಿ. So this is being followed even today also. Now the change what is introduced in this new legislation is like this. All statements, including statements given electronically, which are made before the court by witnesses are called oral evidence. Next slide hogi. So this is the change which has been introduced. So a person can depose before you through electronic mode. For example, a person who is sitting in an Andaman Nicobar, through electronic mode, through electronic apparatus, holding his mobile or a laptop or a computer system, he can appear before you and he can adduce the evidence and his statement can be recorded, and that particular statement is also an oral evidence as per the new definition. So this is the change which has been introduced. Now the question is whether that particular system was available or not. That particular system was recognized by the Supreme Court, but there was no legislative recognition. That is what I am trying to explain. What used to happen is that as per the CRPC, the witness has to make the statement in the presence of the accused. That is one particular provision which is available in the old CRPC as well as new CRPC. So it was interpreted that the witness has to come before the court. That was the concept. Now that particular concept has been retained. However, only thing is that he can appear through electronic mode and he can adduce evidence. In one particular judgment, the Supreme Court has held that statement has to be made in the presence of the accused. That does not mean that the witness has to physically come before the court. It appears that that particular interpretation was given in the year 2003. As per that particular statement, that was in the year 2004, Sakshi versus Union of India. Section 273 of the CRPC was taken into consideration. The Supreme Court held that a witness can appear before the court through electronic mode, and then his or her evidence can be received. The question was, there would be a difficulty for the accused. The Supreme Court said that if the accused can hear, that is sufficient. So that particular issue relating to appearance before the court has been addressed too. So what was held in the Sakshi versus Union of India in the year 2004 has been taken into consideration, and that has been legislatively recognized, statutorily recognized, and now a witness can appear through electronic mode. Now the only question is that whether all the witnesses has to be permitted. A star witness, an eyewitness whose presence is required, whose veracity has to be observed by the judge. In such situation, the discretion is given to you, the discretion given to the learned officers to take a call whether physical presence is required or not. So that particular discretion is not taken away. On the contrary, more discretion has been given to the court whether to examine the witness through electronic mode or whether physical presence is required. If the court feels that the physical presence would be a detrimental, then the court can insist, then the court can pass an order saying that that witness has to appear through electronic mode. So this is one particular change which has been introduced. According to me, it would help the court judicial officer to receive the evidence speedily and decide the cases. For example, an officer, a scientific expert, or a doctor, if he says that today I cannot come, I have a particular work, then the court can insist that through electronic mode you can appear. So this will be very useful. This is one interesting aspect what we can observe. Only thing is that some rules have to be formulated, or criminal rules of practice has to be amended so as to give guidance, give guidelines to the court to how this particular evidence has to be recorded. That is the reason why on pilot basis in city civil court, multiple cameras have been installed. ನಾನು ಹೇಳ್ತಾ ಇರ್ತೀನಿ ಏನು ಅಂತಂದರೆ ಶಾರುಖ್ ಖಾನಿಗೆ ಆ್ಯಕ್ಟಿಂಗ್ ಮಾಡೋದು ಭಾಳ ಈಸಿ. ಯಾಕಂತಂದರೆ 10 ನಿಮಿಷ ಆ್ಯಕ್ಟಿಂಗ್ ಮಾಡಿಬಿಟ್ಟು ಅವ್ನು ರೆಸ್ಟ್ ತೊಗೋಬೋದು. ಇನ್ನೊಂದು ಸತಿ ರೀಟೇಕ್ ಅಂತಲೂ ಹೇಳ್ಬೋದು. ತಪ್ಪಾಗಿತ್ತಂದರೆ ರೀಟೇಕನ್ನು ಹೇಳ್ಬೋದು. ನಿಮಗೆ ರೀಟೇಕ್ ಅಂತ ಹೇಳೋದಕ್ಕೆ ಅವಕಾಶ ಇಲ್ಲವೇ ಇಲ್ಲ. ಅದು ಏನು ಬೆಳಿಗ್ಗೆ 10:45 11 ಗಂಟೆಗೆ ಕೂತ್ಕೊಂಡ್ರಿ ಅಂತಂತಂದರೆ ಸೀಟ್ನಲ್ಲಿ ಬಂದ್ರಿ ಅಂತಂದರೆ ಸಾಯಂಕಾಲ 5:15ವರೆಗೂ ಕೂತ್ಕೊಳ್ಳೇಬೇಕು. ನೋ ರೀಟೇಕ್, ನೋ ರೆಸ್ಟ್, ನಥಿಂಗ್. ಸೊ ಏನು ಅಂತಂದರೆ ಈ ಕ್ಯಾಮ್ರಾ ಫೇಸ್ ಮಾಡೋದೇನಿದೆಯಲ್ಲ, ಇಟ್ಸ್ ಎ ರಿಯಲ್ ಚಾಲೆಂಜ್. ನಮಗೂ ಸಹ ಕ್ಯಾಮ್ರಾ ಥ್ರೂ ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡೋದೇನಿದೆಯಲ್ಲ, ಇಟ್ ಈಸ್ ಆಲ್ಸೋ ಎ ಚಾಲೆಂಜ್ ಫಾರ್ ಅಸ್. ಬಟ್ ಇಂಡಿಯನ್ ಡೆಮೋಗ್ರಫಿ ಎಷ್ಟಿದೆ, ಇಂಡಿಯನ್ ಡೆಮೋಗ್ರಫಿಯಲ್ಲಿ ಬರುವಂಥ ಕೇಸಸ್ಗಳು ಎಷ್ಟಿದೆ, ವೆರೈಟಿ ಆಫ್ ಕೇಸಸ್, ನಂಬರ್ ಆಫ್ ಲಿಟಿಗೇಷನ್, ಆ್ಯಂಡ್ ಆ ಲಿಟಿಗೇಷನ್ಗಳಿಗೆ ಇರುವಂತಹ ನಮ್ಮ ಸ್ಟ್ಯಾಟಿಸ್ಟಿಕ್ ಏನು, ನಮ್ಮ ಅವೈಲಬಿಲಿಟಿ ಆಫ್ ರಿಸೋರ್ಸಸ್ ಏನು, both human resources as well as the infrastructure. For these things, we have to gear up, we have to understand the technology, and we have to use this particular technology. So this is one aspect. There is one more judgment, that is State of Maharashtra versus Dr. Praful B. Desai. in this particular case, again section 273 of the CRPC, old CRPC, regarding statement of the accused in the statement of the witness in the presence of the accused is how it has to be understood and how it has to be interpreted with reference to technological advancement. The Supreme Court said that through electronic mode one can appear. There was one submission which was made before this particular court. Of course, definite finding has not been given by the court. That is, one submission made was that what would be the expenses, what would be the time, what would be the other issues relating to the appearance of the party can be taken into consideration by the learned judges, and thereafter they can decide whether that particular person can seek for the dispensation. That particular argument was advanced before the court that has been captured in this particular judgment. If time permits, please go through that so that it will give certain guidance to you. It will help you how to exercise your jurisdiction with reference to this particular new legislation and how you can dispense with the personal presence of the witnesses. The next change what we can notice here is definition of document. The same structure I have not reiterated what was earlier in the Indian Evidence Act. Spirit of that particular section I have mentioned. The spirit of that definition I have mentioned. Earlier, document means any matter expressed upon any substance by means of letters, figures or marks for the purpose of recording that matter. Very simple. We have been reading this particular definition, and anything which is expressed on a particular substance, that is a document. That was the definition. That particular definition, that particular document definition what was available has been modified in the new legislation. It reads like this. Document means any matter expressed upon any substance by means of letters, figures or marks for the purpose of recording that matter and includes electronic and digital records. Includes electronic and digital records was conspicuously absent in the earlier legislation, in the earlier part of the Indian Evidence Act, even after the 2000 amendment. Though electronic record was available in the definition of evidence, but that was not included in the document. First time it has been included. The one more aspect is that earlier it was only electronic record. In the definition of evidence, it was only electronic record. Now it is not only the electronic record, it is also digital record. Digital record is not defined in the new legislation, that is BSA. It is also not defined in the Information Technology Act. That is one more important aspect. Why the digital record has been introduced, whether there is any difference between the electronic record or the digital record, that we are going to discuss, and some slides I have dedicated for that also. Now, this document, change in the definition of document is very interesting aspect, and it is a game changer according to me. This particular definition of document which is available in this particular new legislation under section 2(1)(d) should be read in conjuncture with section 57 as well as section 61. If we read this particular definition with reference to section 57 as well as section 61, then all these electronic record, if it is produced before the court, then it would be considered as a primary evidence. If these electronic records are received as a primary evidence, all other oral evidence has to be excluded. This is the change. All the oral evidence has to be excluded. So the interplay between the document and the oral evidence, what was earlier we understood with reference to the printed document or a typed document, that particular concept we need to apply with respect of electronic record also. That we will understand when we are heading to the other provisions, more particularly second part of the old Indian Evidence Act. Now, there is one illustration has been included under the section 2(1)(d), that is the definition of document. It was having many illustrations. One more illustration has been included with reference to electronic record. As per that particular illustration, an electronic record on emails, server logs, then documents on computer, laptop or smartphone, messages, websites, locational evidence and voicemail messages stored on digital devices are documents. For example, to reach this particular Karnataka Judicial Academy, I have given a command to my car, take me to the Judicial Academy. That has been recorded and that has been transmitted to my mobile. My mobile has given that signal to the server, that is the internet service provider, and on that basis, map is synced with my car, and the car has given a display how I have to drive my car. So that is a GPRS which I have activated, my location I have activated. On the basis of that, I have come here. I have left digital footprint from my residence to this particular place, from which way I have come, how I have come, which car I have utilized, what is the car number, which route I have adopted to reach this particular place. Everything is available in internet server. It is also available in my mobile. It is also available in the car chip, memory car chip. So all these things are now considered as a document as per the illustration. They have not confined just to the location evidence, server log also. So you can understand what are the document, what are the type of evidences are, what are the types of facts are recognized as document. The next change what we can notice here is the digital record. First we will try to understand the electronic record, then it would become easier to understand the digital record. Electronic record is any information that is created, stored, managed and accessed using electronic means. Created in the sense, we type a particular document. That particular typing, what we do is it would appear on the screen. We will save it either as a Word document or otherwise we will save it any other forum, and that is a typical electronic record. So creation by us, storage, we will store it, save it, then we will manage it, and also whenever we need, we will access it. So this is a typical example of an electronic record. So there are various forms, emails are there, then Word documents are there, spreadsheets, scanned documents, multimedia files. Those are the various types of the electronic record. Now what is digital record? This is the digital record which is introduced first time in this particular legislation. Digital record refers to information that is created and managed using digital technology. The technology creates it, technology stores it, technology manages it. That is digital record. One example kodake ishtapadtini. You dictate to your stenographer, that particular person who is a stenographer types your dictation, and that particular dictation is available in the screen. Either it would be in the Word document or any other document. That particular dictation, once it is completed, she will take the printout and she will provide you the draft. You will correct it. Again, correction will be carried out in the Word document, and final copy will be given to you and you will sign it. And then signed copy is a regular document. It is not an electronic record because you have signed it. Physically you have signed it. So that particular signed document is a regular document. What is stored in your computer is an electronic record. After signing, at the end of the day, you would instruct your stenographer, or you will on your own you will do it. That is, you will upload it to the website. That is a requirement. You need to do that. While uploading, you will not upload it as a Word document. You will convert it into a PDF. Once you convert it into the PDF, then that PDF document you would upload it. The converted PDF document is a digital record. So now the digital record, once again we will try to understand the definition of digital record. A digital record refers to information that is created and managed using digital technology. PDF is an app. This is a digital technology which is available in your mobile or in your computer or in your laptop. With the help of that digital technology, you convert the Word document into a PDF document. That PDF document is a digital record. That concept has been accepted. That concept has been recognized and that has been introduced. This was, even today, this is not available in the Information Technology Act. It is available in the form of an electronic record. But specifically, this particular digital record has been introduced in this particular new legislation. Next slide, Yogi. Some of the examples are PDF, DOCX documents, XLSX documents. The storage will reduce, then encryption is possible, then zip file can be created. These are the advantages of this. Then there are many other type of digital medias are there, using the digital cameras or recording the devices, CCTV footage and all those things. Then there are many digital transaction takes place in our life. For example, travel from your place to Bengaluru, you either through railway you will come, or through flight you would come, or through bus you will come. And you will book the ticket sitting in your office or at your residence using your mobile. That is the digital transaction. That digital transaction is also a digital record that is also recognized here. So these are the various forms of electronic evidence have been recognized with reference to electronic record as well as digital record. Next slide, Igogi. Now, the change, the structural change which has been introduced. For some time, I will refer to the structure also, so as to explain what are the structural changes have taken place. There is a moderate change. There is a cosmetic change only. Earlier, it was section 5 to 55 dealing with the relevancy of fact. Now, it is section 3 to 50. The section 5, popularly understood, any fact which fall under the category of 6 to 55 are relevant fact. That is what we have been understanding that particular section. That particular section 5 is now available in section 3. There is no change. What was earlier section 5 is now section 3. The reason is obvious. Section 2 was repealed in the year 1938. That is completely obliterated. That has been taken care in the new legislation. Section 4 has merged with the section 2. That is may presume, shall presume, conclusive proof. For that reason, the earlier what was section 5, now it is section 4. Then there is one more change. The chapter numbers, the sub-chapters heading have remained as it is. Only thing is that one particular chapter, a proper nomenclature has been given. That is the chapter first part of the first sub-chapter of the relevancy of fact. That is section 5 to 14. That is closely connected facts. That is introduced as a closely connected facts. Next hogi slide. Closely connected facts. If apart from this, there is no change at all. The one more change what we can notice here is with reference to earlier section 6. The earlier section 6 used to deal with the res gestae. That particular concept of res gestae has been retained as it is in section 4. There is no much change. Res gestae concept means acts, declaration and incidents accompanying or explaining the transaction or facts in issue are considered as part of the res gestae. So earlier that particular concept was only restricted to facts in issue. The concept of res gestae has been widened. Now that particular acts, deeds or declaration accompanying with the act with reference to not only with reference to facts in issue, it can be with reference to relevant fact also. This is how the definition of concept of res gestae has been widened, which was available under section 6. Now in new section 4, that concept has been further widened. Next one is admission. Earlier it was section 17 to 23 and 31. Sorry, the relevancy of fact under the category of admission. Earlier it was section 17 to 31. The new chapter, new part is chapter 2, comprising of section 15 to 25, which includes admission as well as confession. The dedicated section in earlier legislation was section 17 to 23 and 31. Those sections are available in section 15 to 21 and 25. See, there are various books have been published with respect of these three legislation. And the Judicial Academy had informed me that there is one particular Home Department website as well as an app has been introduced by the Home Department, Government of India. In that particular app, you can download all these sections. The comparative chart is also given. It is more authentic. And also they have issued certain guidelines to the investigation officer with regard to the zero FIR, how investigation has to be conducted. And those are the guidelines are in the form of a instruction to the investigation officer. I request you to download that particular app and please follow that. That is more authentic and that is more easily understood. Even if a printout is taken also, it would be helpful. So now that particular admission is available in section 15 to 21 and 25. There is no change at all. Next part is confession. There is certain one particular change has been introduced with respect of confession. I will try to explain. Then there is a structural change also. Earlier it was section 24 to 30 dealing with the confession. Now it is section 22 to 24 dealing with the confession. This is the change. What was earlier, there were two concepts are available in the confession. One is relevancy or irrelevancy of confession. For that relevancy and irrelevancy of confession, 3 dedicated sections are available. That is section 24, 28 and 29. Then a confessional statement made to the police officer. That is available in 25, 26, 27. 24, 28, 29 dealing with relevancy and irrelevancy of confession is merged with one particular section. That particular merged section is section 22. So earlier what was section 24, 28, 29 is available in one dedicated section, that is section 22. The concept has not been changed. Only introduction, new component which has been introduced to consider relevancy and irrelevancy of confession is coercion. Earlier coercion was not one of the component to declare it as a irrelevant. Inducement, threat and promise are only the 3 components, and that 3 components were to be considered by the court to consider whether it is a relevant or irrelevant. Now the one more concept has been introduced, that is coercion. That is also because of a judicial pronouncement of the Supreme Court, and that particular judicial pronouncement has been taken care, and that particular concept of coercion regarding the relevancy or irrelevancy has been introduced in this particular legislation. That is K.I. Pouni versus Assistant Collector, Central Excise Collectorate. It was in the year 1997. Supreme Court held that even a coercion is one particular component to be considered by the court regarding relevancy and irrelevancy of a confessional statement. So that has been taken care. Now the legislative effect has been given to. Now this particular section is merged in one particular section, that is section 22. The section 23, new section 23, it deals with another concept, that is a confessional statement made before a police officer. A confessional statement made before a police officer is no confession. There is one particular important section, that is section 27, that is discovery of a fact on the basis of information provided by the accused in his confessional statement would be relevant. That is the concept. That particular concept has been retained as it is. There is no much change. So earlier it was section 25, 26, 27 with reference to confessional statement made before a police officer. That concept which is available in section 25, 26, 27 is now available in section 23. In one dedicated section it is available. All those concepts have been merged and it is available in section 23. What was earlier, we had 7 sections. Now we have only 3 sections with reference to confession. This is a structural change which has been made. And one more change which has been introduced is coercion. Coercion is the another concept which has been introduced to consider whether a confessional statement is relevant or irrelevant. The one more change is earlier a deeming fiction has been introduced, and that particular deeming fiction is available in new section 24. That particular concept was available in old section 30. That is, a confessional statement made by an accused can be used as against the other accused in a joint trial. That is the concept which is available. That particular concept has been retained as it is, but one more thing is that with reference to proclaimed person, proclaimed accused, or with reference to a person who has been declared as a proclaimed offender under section 84 of the new CRPC, that particular confessional statement can be utilized. This is the deeming aspect which has been introduced in the new legislation. Apart from this, there is no change in this particular concept of confession. So if we go to the next part, that is statement by persons who cannot be called as witnesses. That is the dying declaration, section 32, very well-known concept. That particular dying declaration concept is now available in section 26. There is no change at all. Only thing is that that particular section 26 is not just restricted to the person who is dead. That particular section 32 also deals with the persons who cannot be easily brought before the court because of the expenses, because of the place he is residing, because of various other reasons. For that reason, a statement made by that particular person would become relevant under section 32 even though he is alive. Now, because of the change in the definition of oral evidence, one can appear before the court through electronic mode. I personally feel that section 32 or the new section 26 may have to be revisited by the legislator. And that is the one change we may have to come across in future. Or you may have to judicially interpret. You have to say that when he can electronically, through electronic mode he can appear, this particular provision should not be utilized in usual course. So this is one concept which has to be taken care. In future, the legislature as well as the judiciary has to take care with respect to section 32. There is no change in other concept. All other concept in the earlier part has been retained as it is. The next next concept is statements made under special circumstances. This is one particular section which I just want to refer to. That is section 39. How much of a statement to be proved is the question. With reference to one particular judgment of the Supreme Court, Arjun Pandit Rao Kotkar, I need to make my submissions. With reference to that particular judgment, this section 39 assumes lot of importance. The Supreme Court in that particular judgment has held that the internet service provider, telephone service provider, cell phone service provider are duty bound under section 39 to extract that particular portion of a material and produce before the court. For example, CDR detail. If that particular service provider is called upon to produce the CDR details, he will produce entire complete CDR details to you, before you. But it is very difficult to extract that particular relevant portion. With referring to section 39, the Supreme Court has held that it is a duty. A duty is cast upon the service provider to extract that particular relevant portion and produce before the court. So section 39 in view of the new legislation would assume lot of importance. And you have to utilize this particular section to give the directions to the service providers. The next change what we can notice is with respect of judgments of the court. Earlier it was section 40 to 44. Now it is section 34 to 38. No change. There is no change. The concept of judgment in rem, judgment in personam, what is available in section 40 to 44 in the old legislation has been retained as it is, and it has been continued in the new legislation also. Only thing is that there is one particular change with reference to section 41. Section 41 of the old act says that judgments with reference to exercise of the jurisdiction by the court with reference to probate jurisdiction, admiralty jurisdiction, matrimonial jurisdiction, and insolvency jurisdiction, those judgments are judgment in rem and it is relevant. That is the concept which is available in section 41. Now, the insolvency jurisdiction was conferred with the High Court of Karnataka earlier. After the Companies Act, after the new Companies Act which was introduced in the year 2013, the jurisdiction of insolvency jurisdiction has been conferred with the NCLT. Company Law Tribunal has the jurisdiction. Taking that particular change in the law and as well as various other changes where that such type of jurisdiction has been conferred with the new tribunals which are established. For example, there is a discussion or there is a one particular legislation, draft legislation is available which confers the insolvency jurisdiction of individual or a person with the debt recovery tribunal. For that reason, the change we can notice in section 35, what it says that judgment of tribunal are also relevant. So now it was only restricted to the court, and that is the reason why the nomenclature of the earlier Indian Evidence Act of this particular portion was judgment of court of justice when relevant. Word justice has been removed. Now it is judgment of court when relevant, because the tribunals are trappings of the court. The judgment rendered by them or the orders passed by them have been taken care, and this is the change which has been introduced in this particular subchapter. The next one is opinion of third person when relevant. There is no change at all. There is no change. Entire concept has been retained as it is. Only thing is that earlier it was restricted to 4 or 5 areas only where the opinion could have been received as a relevant. Those 4 or 5 areas were, next slide hogi, were foreign law, science, art, identity of handwriting, and finger impression. These 5 categories have been retained as it is. In addition to that, they have introduced another concept, another area in which opinion can be rendered and it can be received as a relevant fact, that is any other field. For example, if a cost accountant opinion is rendered, we could not able to receive it, or a chartered accountant has given his opinion, it was difficult to receive it. For now it is very easy, because the one more category has been introduced, that is any other field. This is the new change. This is the new provision which has been introduced. Apart from this, there is no other changes. Next one is with reference to character when relevant. All the concept relating to the character with reference to civil cases as well as criminal cases have been retained as it is. There is no change at all. There was one particular amendment in the year 2018. Section 53A was introduced to protect the victims of sexual offense. The defense used to pose the question regarding her past sexual experience. By virtue of this particular amendment, the defense was restrained to pose the question regarding her sexual experience. Both the defense as well as the prosecution restrained from posing the question relating to her past sexual experience. That particular concept, what was available in section 53A, has been retained as it is, and a dedicated section has been given, that is section 48. So you can understand where there is an increase in the number, where there is a structural change. Earlier it was 53 with a suffix of A. Now there is a dedicated section, section 48. So these are the changes what we can notice in this particular part relating to relevancy of fact. Of course, there are other changes which have taken place. Regarding the change in the city, there is a change in some of the illustration. The concept has been retained as it is. I am not highlighting all those things. Those are the cosmetic change or a minor changes, so I am not highlighting those things. So the next concept where we can notice the electronic evidence is with reference to on proof. Earlier it was section 56 to 100, now it is section 51 to 103. So 56 to 100, the same concept, now it is available in 51 to 103. The first part, that is on proof, facts which need not be proved, now it is available in 51 to 53. So the same concept is available, there is no much change. Next slide, Gogi. Only thing is that with respect to judicial notice, there is one particular change. Now the court can judicially take the notice of the international treaty to which the India is a signatory, international agreement. There are various legislations, more particularly special legislation. For example, NDPS Act. Those are, such type of legislations are based upon the international convention or treaty. So if there is any new concept which has been introduced in the NDPS Act, we used to refer to international treaty, or the court used to refer to international treaty. But whether the court can take the judicial notice of that particular international treaty was an issue. Now by virtue of this particular amendment, the court can take judicial notice of international treaty. Only rider is that India should be a signatory, more particularly PMLA Act. PMLA Act is based upon a Preliminary Convention. So now we can refer to the Preliminary Convention because it is a judicially noticeable. So this is one change which has been introduced with respect of judicial notice. The next change where we can notice and interesting facts are Section 59, Section 60 deals with the oral evidence. The same concept has been retained as it is. Now it is Section 54 and 55. The Section 59 is with reference to proof of facts by oral evidence. The same thing has been retained as it is. Next slide, okay. Now, earlier it used to read like this. After the amendment in the year 2000, earlier the Section 59 used to read like this. All facts except the contents of document or electronic record may be proved by oral evidence. Now, Section 54, that is the new section in the new Adhiniyama, it reads like this. All facts except the contents of documents may be proved by oral evidence. There is a deletion of electronic record in the new Section 54. Deletion, the reason for deletion is there is a change in the definition of document. Since the electronic record has assumed the status of document by virtue of amendment, by virtue of the new legislation, specifically the word electronic record is not mentioned in Section 54. This is a game changer according to me. Because earlier the oral evidence is one type of an evidence. The documentary evidence is another form of an evidence. The documentary evidence was not including the electronic record. The electronic record was considered another form of evidence, though it was not specifically, it was not declared. Now, the electronic record as well as the digital record have assumed the status of document. This is how the new section reads. According to me, it has a cascading effect over the entire legislation, which we can notice in the various places of this particular legislation. So, next slide, Yogi. The next one is the oral evidence must be direct. That is the best rule evidence, best principle that is retained as it is, that there is no change at all. Now, the next one is documentary evidence. Earlier, the documentary evidence, Section 61 to 90 used to deal with the documentary evidence. Now it is Section 56 to 93. Section 61 to 73 deals with proof of contents of document. So it comprises of 13 sections. 13 sections under the old act used to deal with the contents of a document. Now it is Section 56 to 73. Totally there are 18 sections are there with respect to proof of contents of document. There is a changes what we can notice here is. The first change where we can notice is Section 61 is an addition to the BSA. We will come back to that particular addition. First one is with reference to primary evidence. Section 57. Primary evidence, which was new section relating to primary evidence. Earlier it was restricted to only documents. And there were 2 explanations which were available. Now there is an increase in the explanation. Now we have 7 explanations with reference to primary evidence. Out of 7 explanation, the 4 explanation is with reference to electronic evidence. What are those explanations? We will try to understand. One ಸ್ವಲ್ಪ ಹಿಂದೆ ಬನ್ನಿ. So primary evidence now expressly includes the electronic and digital records. Section 57 is a primary evidence with reference to documents. Old Section 62 is now the new Section 57. Those 4 explanations with reference to electronic record which is available in the new legislation, we will try to understand. First explanation, that is explanation 4 to new Section 57, it reads like this. Where an electronic or digital record is created or stored and such storage occurs simultaneously or sequentially in multiple files, each such file is a primary evidence. This is a new concept which has been available. What used to happen is that we used to produce the document before the court, making a statement that this particular document is available in my mobile, it is available in my computer because my computer and mobile are synced with each other, and it is also available in cloud. And then we used to produce it from the cloud and we used to produce before the court. Then the court, because of the various judgments and various interpretations, the court used to say that this is a copy and there is a need of compliance with 65B. If you have downloaded from the cloud and if you are producing it before the court, it is a copy. And that is how it was treated as a secondary evidence. It did not have the position of a primary evidence or did not assume the position of a primary evidence. That has been addressed. Now what it says that if an record, electronic or digital record, is created or stored and such storage occurs simultaneously or sequentially in multiple files, each file is a primary evidence. For better understanding, I will give one illustration with reference to our day-to-day life. I am cross-examining before you. You are recording the statement of a witness. You are dictating to your stenographer. The lady stenographer or a person is taking the dictation. Suddenly there is a loss of power. Then immediately you would pose a question to the stenographer whether you have saved. She will nod her head and she will say that yes sir, it is saved. And then further she will make a statement, even if I have not saved, if it is not saved, it would be available in the server. So what computer we had in the year 2000 was a standalone computer. Now we don't have a standalone computer. Our computers are connected with the server. Servers are connected with the grid. That particular concept has been taken care. Similarly, my phone is connected with the laptop. My laptop, in the files which are available in my mobile as well as my laptop is also available in cloud in the form of a server. That has been taken care. So each file is now, wherever it is available, is considered as a primary evidence. So this is the concept which has been introduced. The second one is where an electronic or digital record is produced from proper custody. The importance of this explanation is proper custody. Is produced from proper custody, such electronic and digital record is primary evidence unless it is disputed. For example, this is an electronic apparatus. And I have produced this before the court. I am the owner of this, I have the custody, and I am producing it. And then I am not required to file an 65B certificate because I am producing my mobile as it is and as well as the computer output. By the computer output or a printer, along with that I am producing it, and then it would be received as a primary evidence. So this has emanated, from a proper custody. If it has not emanated from a proper custody, for example, I have stolen mobile of my wife and stolen mobile of my wife I am producing before the court. In such an event, it is not a primary evidence. But there is one particular concept has been introduced, that is unless it is disputed. If the other party, if he won't dispute it, then it will be received as a primary evidence. If the other party disputes it, of course it would be marked subject to the objection, but the reverse burden would be cast on the other side, particularly accused, to show that it has not come from the proper custody. This is the change. This is the interesting change which has been introduced by this, by this new legislation. The next one is where a video recording is simultaneously stored in electronic form and transmitted or broadcast or transferred to another, each of the stored recording is a primary evidence. For example, this video recording, it is not with reference to electronic record or digital record. It is restricted to video recording. Now, whatever the session being conducted, our participation is being recorded in this particular camera. That particular recording, if it is streamed, if it is available in the intermediaries service providers, then you try to understand. A video recording is simultaneously stored. So it is being stored in this particular camera. At the same time, it is also streamed, it is broadcasted and transmitted or transferred to another. Each of the stored recording, what is available in this camera, what is available in the server of the intermediary, each recording is primary evidence. So this is another change which has been introduced. For example, I have saved one particular video that is available in my mobile. For some reason, I have transferred that particular saved file, that is video, to another person or who is my friend. What is transferred to another, that is the word which has been utilized. What is transferred to another, that particular file is also primary evidence. This is the new concept which has been introduced, and it is a primary evidence. Please imagine the recent two cases which is being deliberated in all the media as well as all of us. That particular incident has been recorded, it has been circulated, it has been transferred. Each transferred file, each storage which is available in other apparatus, that is a video, is a primary evidence. Once it gets a status of primary evidence, I can understand how you people are going to judge these type of cases. So this is another interesting aspect in this particular legislation. That is the spirit of this particular act. The next one is where an electronic or digital record is stored in multiple storage spaces in a computer resource, each such automated, please next line, each automated storage including temporary file is primary evidence. Even a primary file is also primary evidence. For example, I have my mobile. I have realized that tomorrow the police are coming or today evening they are coming and they are going to arrest me. Immediately sensing apprehending my arrest and also understanding that this particular mobile is likely to be used against me, I immediately erased all the data available in this mobile. Then immediately the police seizes this particular mobile, and this particular mobile is sent to the one particular forensic expert, electronic forensic expert, particularly in Karnataka, Cellbrite company. That particular company will extract all the files which are available even if it is erased. All those files are temporary files. Those temporary files are also primary evidence. So you can imagine if the investigation officer is active, aggressive, and he wants to help the judiciary for dispensation of justice, what all the things he can do, how he can bring the evidence before you, how he can help the court. Of course, it is a joint effort. Unless he produces, we cannot do it. But if he produces it, how we can decide the cases, how you can dispense with the justice, and how you can try to the actual happenings. So this is one aspect which we can understand. With reference to the video recording, once again I will refer to the video recording. Just imagine the CCTV footage. The CCTV footage earlier was a standalone apparatus. Now each of the CCTV footage, most of the time, it is connected with the server. For example, so many CCTV footage, so many CCTV are installed by the police after the Nirbhaya case, under the scheme of Nirbhaya, all over the city. And that particular CCTV footage, CCTV is connected with the server. Whatever the storage which takes place in that apparatus is also stored in the server. And the police, not even going to the particular place, in their war room they can watch what is happening in the city. That can be produced. And what if it is produced, it is a primary evidence. So this is the concept which has been introduced under section 57. Now please understand this particular explanation to the primary evidence, that explanation 4, 5, 6, 7, with reference to the definition which is available in the new legislation with reference to document. Try to understand one situation. A witness who has appeared before you, who is an eyewitness, that particular eyewitness has turned hostile. But there is a CCTV footage. That particular CCTV footage has recorded complete crime scene. Once that particular CCTV footage has recorded the complete crime scene, what is the need of that particular witness who has turned hostile? Earlier witness, in the simpler world, on the basis of a human memory, who is a God-fearing, used to take the oath and make the statement. Of course, I am not belittling them or belittling anyone. But only thing is that when we have a document, when we have a real-time evidence, that real-time evidence explains the entire event, and it gives complete picture who is the person, who is an assailant, who has attacked, where the person has received the blow. All those things you can see. Who is the person participated in the crime, who was just a person sitting, who was just a spectator, or being a spectator, there was no role played by him, or being present there, he used to give the instruction to hit that particular person. All those things you can see. On that basis, you can decide. According to me, not in our time, in future, what would happen is that there will be a real-time electronic evidence. That real-time electronic evidence would be produced before the court. The moment the charge sheet is produced before you, you will immediately go to that particular real-time electronic evidence. That particular electronic evidence you would see in your computer. Then you would call upon the accused, give your evidence, provide your evidence. Immediately, we will jump to the stage of 313 statement. Of course, I am entitled to take the extreme views. This is my view. Because this real-time electronic evidence would exclude all other oral evidence. We may reach that particular stage if there is a cooperation from other person, that is the investigating agency. Okay, now the interesting part here is, there is one particular judgment of the Supreme Court. I just want to mention it. There was this particular situation we may come across for that reason. There was some obscene materials in the electronic evidence that was produced before a female judicial officer. Then she made a request to the registry to transfer the case to some other male judicial officer. That was done. That was challenged before the Supreme Court. The Supreme Court said that, no, it is a call of the duty. Even if you are a female member, even if you are a female judicial officer, you need to decide that case, and it is a call of the duty. Of course, there is one particular the observation has been made by the Supreme Court that is very important, that if the female judicial officer feels embarrassed, then in that event, that judicial officer can ask all the members in the court hall to remain away from the court proceedings, and then she can view that particular the obscene picture or whatever the electronic record. Thereafter, she can resume the work, or thereafter she can call upon other person inside the court. Similarly, it is applied to us also. So this is the call of the duty. This is how the Supreme Court has interpreted. So I have not referred in my slide, and that is a very important legislation, because when even my wife is also an advocate, she is on the prosecution side. Most of the time we will come across this type of a situation. I also appear for the defense side as well as the prosecution side. In one particular case, when it was listed before the division bench, I was appearing for the accused who were acquitted. So I was appearing on their behalf as a respondent. Then the matter reached around 1:15. The court posed me a question. Mr. Madhukar, have you seen the original photographs? ನಾನು ಜೆರಾಕ್ಸ್ ಕಾಪಿ ನೋಡಿರೋದು, ಒರಿಜಿನಲ್ ನೋಡಿಲ್ಲ ಅಂತ. ನಾನು ಜೆರಾಕ್ಸು ನೋಡಿರಲಿಲ್ಲ ಅಂದ್ಕೂಡಲೇ ಈಗಲೇ ತೊಗೊಂಡು ನಾನು ನೋಡ್ತೀನಿ ಅಂತಂದರೆ. Then the court instructed me, no, first you have your food. Come back at 2:15. Look into the file. Then make your submission at 2:30 ಅಂತ. ಆಮೇಲೆ ನನಗೆ ಅರ್ಥ ಆಗಲಿಲ್ಲ ಯಾಕೆ ಹಿಂಗೆ ಹೇಳ್ತಾ ಇದ್ದಾರೆ ಅಂತ. ನಾನು ಮಧ್ಯಾಹ್ನ ಆ್ಯಸ್ ಯೂಶ್ವಲ್ ಕ್ಯೂರಿಯಾಸಿಟಿ ಹೆಚ್ಚಿಗೆ ಆಗ್ಬಿಡುತ್ತೆ. ಹಂಗಾದ್ಮೇಲೆ 2 ಬಾಳೆಹಣ್ಣು ತಿಂದೆ, ಇಮ್ಮಿಡಿಯೇಟ್ಲಿ ಬಂದುಬಿಟ್ಟೆ. 1:45 ಅಂದರೆ ಬಂದುಬಿಟ್ಟೆ, ಕೋರ್ಟ್ ಫೈಲ್ ಕೊಡಿ ಅಂತ ಕೋರ್ಟ್ ಆಫೀಸರ್ಗೆ. ಅದನ್ನು ನೋಡಿದೆ. ಅದು ನೋಡಿಕೊಳ್ಳೆ ವಾಂತಿನೇ ಬರಬೇಕು. ಪುಣ್ಯಕ್ಕೇನು ಅಂದರೆ 2 ಬಾಳೆಹಣ್ಣು ತಿಂದಿದ್ದೆ, ಪುಣ್ಯ. ಸೊ ದೆನ್ 2:30 when the court resumed its work, the question was posed to me, have you seen that particular photograph? Yes. So now you start arguing. See, the photographs, real-time evidence, videos, it is so helpful for us. Yes, it will act upon us. It will also guide us to decide the matter. It will guide us also. So this is the advancement in the technology. This is how it is going to help us. So next one is section 61. Section 61 is a declaration. That particular declaration, next slide, that particular declaration is that the electronic evidence and digital evidence cannot be denied on the ground that it is a electronic record. This is a declaration which has been made. Very interesting declaration. No such declaration we found in earlier Indian Evidence Act or even after the amendment. So on the ground of it is being an electronic record, the court cannot deny it. It has to be received either as a primary evidence or as a secondary evidence with the certificate. Further it says that, next slide, further it says that it has the same effect of a document, validity of a document, enforceability of a document. This is another declaration which has been made in this section 57. Along with the 61, you can understand what is the importance of electronic evidence or electronic record. And then you can understand how you have to judge the cases. According to me, this is a game changer. Yes, madam. Yes, madam, that argument will be made. Then in that event, whatever the provision which is available in this particular act regarding the integrity of the document and regarding that modification which has been made, in that event, if the other side is arguing that particular, he is advancing that particular document, if it is a primary evidence, if it is produced before the court, he can seek for the reference of that particular document to the expert. And if the expert report comes before you, and if the expert report says that there is a mutilation of the document, there is a change in the document, definitely that particular document lose its efficacy. But if the report says that, if that particular deposes before the court that it is intact, then that document has to be received. Sorry, it has been already received. It will have more evidentiary value. That is the concept. So section 61 is a game changer. 57, 61 is a game changer. So electronic records, all the CCTV footage, everything what is being produced, whatever the argument we use to advance on behalf of the accused, on behalf of the defense, now we have to change our submissions. We have to address the argument accepting that particular electronic record, and accordingly we have to argue before you. The next one is the secondary evidence. The concept of secondary evidence, primary evidence and secondary evidence with reference to document as it is, it has been written. I am not going to touch upon it. Then there is a change with respect of secondary electronic evidence. Secondary electronic evidence, what was available in section 65A and B has been retained as it is. Now there is a dedicated section with the proper numbering, that is section 62, 63. So section 63 is 65B. Section 63 says that if a party wants to produce secondary electronic record before the court without producing the apparatus, without producing that particular electronic equipment, in such an event, he is supposed to fill a form which is available in part A of the schedule appended to the act, along with that particular computer generated printout or computer generated output. So this is the mandatory requirement. Earlier what we used to do is that I had my own format, my office format. We had one particular affidavit format. I used to file that particular affidavit before you, and that particular document used to be received, or that particular electronic record used to be received on record. So there was no standardization. Every office had their own formats. That particular concept has been done away with. So they have provided a format that is a technical document. It has to be filled, and in addition to all other technical details, hash value has to be explained. When I was new to this profession, my senior was not so well equipped with the technology. So it is very common. So then I used to inform that, sir, 7:30 ಆಗಿದೆ, ನೀವು ಮನೆಗೆ ಹೋಗ್ಬಿಡಿ, ನಾನು ಟೈಪ್ ಮಾಡಿಬಿಟ್ಟು ಡಾಕ್ಯುಮೆಂಟ್ ಎಲ್ಲ ನಿಮ್ಮ ಮನೆಗೆ ಕಳಿಸ್ಬಿಡ್ತೀನಿ, ನಿಮ್ಮ ಮಗ ಅದನ್ನು ಪ್ರಿಂಟೌಟ್ ತೊಗೊಂಡ್ಬಿಟ್ಟು ನಿಮಗೆ ಕೊಡ್ತಾರೆ. ಅದು ಹೇಗೋ ಆಗತ್ತೆ ಅಂಥೇಳಿ, ನಂದೊಂದು ಇಮೇಲ್ ಇದೆ, ನಿಮ್ಮ ಮಗನ ಇಮೇಲ್ ನನ್ನ ಹತ್ರ ಇದೆ, ನಾನು ಕಳಿಸ್ತೀನಿ ಅಂತ. ಹೌದಾ ಅಂಥೇಳಿ ಕೌತುಕದಿಂದ ನೋಡ್ತಾಯಿದ್ರು. ಈಗ ಎಲ್ಲರ ಹತ್ರನೂ ಇಮೇಲ್ ಇದೆ, ಅದೇನು ಪ್ರಶ್ನೆನೇ ಇಲ್ಲ. ಸೊ ದಟ್ ಈಸ್ ಹೌ ವಿ ಯೂಸ್ ಟು ಡೂ. ಅದು ಹೆಂಗೆ ಮಾಡ್ತೀರಾ ಹೇಳು ಅಂತಂದು ಕೂಡ ನಾವು ಜಾಸ್ತಿ ಹೇಳೋದು ಅಥವಾ ಹೇಳ್ತಿದ್ವಿ ಅರ್ಧಂಬರ್ಧ ಹೇಳಿಬಿಟ್ಟು, ಅಥವಾ ನಮ್ಗೆ ಹೇಳೋಕ್ಕೆ ಬರ್ತಿರ್ಲಿಲ್ವ, ಅಥವಾ ಭಯದಿಂದ ಸರಿಯಾಗಿ ಹೇಳ್ತಿರ್ಲಿಲ್ಲ. ಈಗ ಎವ್ರಿ ಒನ್ ಹ್ಯಾಸ್ ಎ ಇಮೇಲ್ ಅಕೌಂಟ್. ಅವರ್ ಫೋನ್ಸ್ ಆರ್ ಕನೆಕ್ಟೆಡ್ ವಿತ್ ದ ಇಮೇಲ್ ಅಕೌಂಟ್. ನಾನು ಮೊನ್ನೆ ನನ್ನ ಕಲಿಗೆ ಕೇಳಿದೆ, ಅದು ಹೆಂಗೋ ಹ್ಯಾಶ್ ವ್ಯಾಲ್ಯೂ ತೆಗಿಯೋದು ಹೇಳ್ಕೊಡೋ, ಯಾಕಂದ್ರೆ ಶೆಡ್ಯೂಲ್ನಲ್ಲಿದೆ ಹ್ಯಾಶ್ ವ್ಯಾಲ್ಯೂ ಹೇಗೆ ತೆಗಿಯೋದು ಅಂತ. ಸರ್ ಭಾಳ ಸಿಂಪಲ್ ಅಂತ ದಿನಾಲೂ ಹೇಳ್ತಾನೆ, ಆದರೆ ಅವ್ನು ಹೇಳ್ಕೊಡಲ್ಲ ನನಗೆ. ಸೊ ನಾಳೆ ಇನ್ನೊಂದು 10-15 ವರ್ಷ ಹಾಕೊಳ್ಳಿ ನಮ್ಮ ಪರಿಸ್ಥಿತಿ ಏನಾಗ್ಬೋದು. ನಾನು ಹೇಳಿದೆ, ನೀನು ನನಗೆ ಹೇಳ್ಕೊಡ್ಲಿಲ್ಲ ಅಂದರೆ ನಿನಗೆ 10-15 ವರ್ಷ ಆದಮೇಲೆ ನಿನಗೂ ಹಿಂಗೆ ಆಗತ್ತೆ ಅಂತೇಳಿ ಅಂತ. ಸೊ ಸೊ ವಾಟ್ ಐ ಯೂಸ್ ಟು ಡೂ ನೌ ಮೈ ಕಲೀಗ್ಸ್ ಆರ್ ಡೂಯಿಂಗ್ ವಿತ್ ಮೀ. ಸೊ ನಿಮ್ಗೆ ನೆನಪಿರ್ಬೋದು ಏನು ಅಂತಂದರೆ, ಮನೆಯಲ್ಲಿ ಸಹ ವಯಸ್ಸಾದವ್ರು ಇರ್ತಾರಲ್ಲ, ಅವ್ರಿಗೆ ಮೊಬೈಲ್ ಉಪಯೋಗಿಸೋಕೆ ಬರಲ್ಲ, ಪರ್ಟಿಕ್ಯುಲರ್ಲಿ ಸ್ಮಾರ್ಟ್ ಮೊಬೈಲ್. ಸೊ ಅದನ್ನು ಹೇಗೆ ಆ್ಯಪ್ ಡೌನ್ಲೋಡ್ ಮಾಡಿಕೊಡು, ಅದರಲ್ಲಿ ಬೇರೆ ಬೇರೆ ಏನಂತ ಅಂದ್ರೆ ಹೇಳ್ತಾರೆ. ಆಮೇಲೆ ವಿಡಿಯೋ ಕಾಲ್ ಮಾಡಿಕೊಡು, ಮಗಳ ಜೊತೆ ಮಾತಾಡ್ತೀನಿ ಅಂದ್ಕೊಳ್ಳಿ, ನಾವು ಅಸಡ್ಡೆಯಿಂದ ಮಾಡ್ಕೊಡ್ತೀನಿ ಅಂದ್ಕೊಳ್ಳಿ ಆಮೇಲೆ ಅಂತ. ನನ್ನ ಮಗ ಅಂತೂ ಅದೇನು ದೊಡ್ಡ ಪ್ರೈಡ್ ಅಂತ ತಗೋತಾನೆ. ನಮ್ಮ ತಾಯಿಗೆ ಹೇಳ್ತಾನೆ, ಮೊದಲು ಒಂದು ಸ್ವಲ್ಪ ಏನಾದರೂ ಸ್ವೀಟ್ ಏನಾದರೂ ತೊಗೊಂಬ, ಆಮೇಲೆ ಮಾಡ್ಕೊಡ್ತೀನಿ ಅಂತ ಹೇಳ್ತಾನೆ. ಸೊ ಈ ರೀತಿ. ಸೊ ಟುಡೇ ವಾಟ್ ವಿ ಆರ್ ಫೇಸಿಂಗ್, tomorrow they will also face, the youngsters also will face. So this is the technology, we have to adapt with this technology, we have to follow this particular technology, and these are the changes what we can notice here with reference to electronic evidence. So definition of document, section 57, then section 61, then section 62 and 63 these are the various provisions which we need to keep in our mind while receiving an electronic record or a digital record. This according to me, this is a game changer, and it is ultimately you people are going to utilize these provisions to decide the cases. After 3 or 4 months, you would have your own opinion, you would form your own opinion, and you will start discussing with all of us. So this is the change. And the next one is the munde hogi tondre illa. See, the change what we can notice here is the legal effect what we have noticed in section 61. Next one, the earlier section 62, that is the secondary evidence, that is section 65. New section 63 deals with the secondary evidence as well as certification. Earlier it was restricted to secondary electronic evidence as under section 65A and B. It was restricted to communication device. Now it is not just restricted to communication device. There are other devices have been included. So the concept has been widened. So this is one change what we can notice in new section 65B. Then scope of devices have been enlarged. That is what I have explained. Then there is one more aspect, specified format. There is a specified format which is available in schedule. That is what I was explaining. The earlier, this was done simply by filing an affidavit. The simple affidavit will not sufficient. That is what this particular legislation says. Then there is one more change, that is the introduction of intermediary. So Facebook, Google, and YouTube, various other intermediaries are included in this particular 65B. So whatever we see, whatever which can be seen in the intermediary services, that can be produced before the court along with the 65B certificate, with giving that particular reference, that particular tag which is available in the computer, referring to explaining that particular tag, we can produce before the court along with a certificate. That is a new introduction which has been made. One more thing is that person in charge, there is a change in the person in charge. Earlier, owner or a responsible person, owner was required to file the 65B certificate. It is not so now. Any responsible person who is acquainted with that particular apparatus or that particular computer, he can also give a certificate. This is one more change which has been introduced here. So this is up to the electronic evidence. The presumption. With reference to the presumption what is available, of course there is one more change what we can notice. Earlier section 74 of the Indian Evidence Act used to deal with the public document. Then section 75 used to deal with the private documents. Both this public and private document were having a dedicated section. both this concept has been merged in one particular section, that is section 74. Section 74 subsection 1 deals with the public document. Section 74 subsection 2 deals with the private document. This is one change what we can notice. The next one is presumption as to documents. So here, with reference to presumption as to document, what was earlier available with reference to electronic record, electronic transaction, electronic agreements, electronic signature has been retained as it is. Those presumptions have been retained as it is. So that we need to understand. But those presumptions were with reference to secondary electronic record. Yes, of course, those presumptions were with reference to primary electronic record also. But the concept of primary electronic record has been enlarged. So the presumption, what is available in the new legislation, would receive lot of importance. More particularly, there is one particular presumption with reference to secured electronic record. What is secured electronic record? This is my understanding. I will try to explain. The judgment which you have rendered, that particular judgment, you have affixed your digital signature. Digital signature is an encrypted one. It is a password protected. Then there is one QR code also attached. With the help of that particular QR code, we can scan it and we can directly go to the server and we can view that particular document. So when that particular QR code is affixed and when that particular digital signature is affixed by you, then that would become a secured electronic record. That concept would assume lot of importance. I'm just giving an example. Such type of secured electronic record we come across in our life, in our day-to-day life. For example, my income tax returns. There are various such type of secured electronic records are there. There are various other electronic records which are officially available, which are available in official website, which are produced before you with the QR code. So then presumption can be drawn with the help of this particular legislation, with the help of the presumption what is available in this particular part. So that we need to understand. There is one more concept that is a new thing that is in the offing, that is electronic signature and digital signature. There is a marked change in that also. The digital signature is your digital signature which is provided to you, and that is encrypted one. Even I have a digital signature. By visiting a Mudra website, that is a website of the government of India, I have received one particular electronic digital signature. So I affix that particular digital signature. The electronic signature is another signature where one can sign with the help of a stylus pen. So when a particular person delivers the checkbook to you, then he will give his stylus pen and he will ask you to sign on the one particular tab. On that particular tab on the screen you have to sign it, and that particular signature would be uploaded. That would be a digital database. So that is an electronic signature. So that particular concept is offing, and that is another concept which we have to cope up and we have to understand it. So these are the various changes which has been introduced, and these changes are, according to me, game changer. So the next changes what you can notice here is there are certain provisions which have been deleted. For example, with respect of telegraphic message. So the postal department is not providing the telegraphic services. For that reason, that particular presumption that has been completely removed. The jury concept which we have in the present legislation, that is Indian Evidence Act, it is not being followed because that is not being adopted by us. So that particular jury system which was earlier available in British India, it has been completely done away after the 1950. So that particular provision has been completely removed, that has not been carried in the new legislation. Then there are certain other changes which we can notice with respect of, there is no change in the exclusion of oral evidence, that is section 91 to 100, that is now available in 94 to 103. Only my understanding is that in the next legislation, there will be one more part, that is exclusion of all other evidence, exclusion of all other evidence by real-time electronic evidence. So that is the next concept which has to evolve upon, and that particular concept would come up. That is my understanding, that is my hope also. The other changes what we can notice here is this particular production and effect of evidence, as it is, it has been retained. That is only one particular chapter has been introduced, that is chapter number 12. Earlier this particular chapter was not there. Earlier legislation, the Indian Evidence Act is the first legislation with reference to principles law relating to evidence. So there was no occasion to have repeal and saving clause. Since this new legislation is repealing the earlier legislation, this particular chapter number 12 with section 1, dedicated section 170 has been introduced. The section 113 dealing with the proof of cessation has been completely removed. There is no need of having such type of a section. Then 166 relating to the jury system, that has been removed. Then the 126 of the old act deals with the privilege relating to professional communication, and that particular section now it is available in 132. That 126 privilege what we have, being an advocate, privilege communication between me and my client, that was extended to my clerk as well as other persons who work with me as a paralegal staff as per section 127. Both those section 126, 127 has been merged into one section, that is 132. There is one particular judgment of Canada, I just want to refer that. There is a concept called as computer illiterate. What happens is that in that particular case, it is a matrimonial dispute between husband and wife. Then husband was having a relationship with one particular lady who happens to be his girlfriend. So entire his documentation regarding that particular litigation, she used to prepare on his behalf because he is computer illiterate. Then there was a fallout between them. Then after the fallout, she goes and she gives the entire material to the wife. And then he takes a contention before the court that I am a computer illiterate and she could not have done that. She was my girlfriend and that particular document she could not have shared with my wife, and my wife cannot use that particular document. That is one submission he makes before he submit before the court. The court did not appreciate that particular submission. And if I am a computer illiterate, what are the difficulties in life we need to understand. So if in my office, my colleagues knows my Google account password. Same with you people also. My son knows my password. My entire office knows my Google account password, my bank transaction, everything. I cannot claim to be a computer illiterate also. I claim to be a computer semi-illiterate. So this is the situation, but we have to adapt ourselves. If we have to adjust with this life, if I have to discharge our duties, then we have to adjust with that, and we have to understand the technology. For that reason, I have deviated the subject. I am just giving an example. Very interesting case. I can't pronounce the name, Ijistan, something like that. That is the name of the party. Ijistan versus Ijistan or something like that. If you get an opportunity, please read it. Then the earlier one, the leading question, that was section 141 to 143. Those three sections have been merged into one particular section. That merged section is 141. That 141 explain what is leading question. 142 states when leading question can be posed, may be posed and may be asked. Then section 143 states when leading question may be asked. So that particular 141 to 143 are merged into one section, and it is numbered as section 146. Section 146 now deals with the leading question, and entire concept of leading question, what was available in the old Indian Evidence Act, is now available in 146. Then section 111 regarding presumption as to certain offense, then presumption as to abatement of suicide, 113 presumption as to dowry death, then 114 presumption as to absence of consent in certain prosecution of rape. All those are retained as it is with a proper numerical number. So there is no the suffix like A, B, C. Now it is 115, 117, 118, 120. There is no change in those concepts. That has been retained as it is. Then the last one, last leg of this session, that is Arjun Pandit Rao Kotkar versus Kailas Rao Kushan Rao Gorantyad. Very interesting judgment, and it will, whatever discussed in this particular legislation, whatever comparative analysis of various provisions of relating to electronic evidence of various other countries, particularly UK, USA, Canada, has been, what is discussed in this legislation has been taken care of in the new legislation. I will try to explain what is the brief facts of this particular case, then you can understand. There was an election, you must be knowing, but still I will try to refresh your memory, I will try to explain it. There was an election for one particular constituency of Maharashtra, MLA election, Jalna constituency. Then in that particular election, two persons, the contesting party are Arjun Pandit Rao Kotkar as well as Kailash Rao, Kushan Rao, Gorantyad. Both they submitted the nomination paper. Then election was held. Then Arjun Pandit Rao Kotkar was declared as a elected candidate by the returning officer. Then Kailas Rao, Kushan Rao, Gorantyad instituted a suit invoking the original jurisdiction of High Court of Bombay, and that particular case he prayed for declaration that election of Arjun as null and void. One of his contention was that Mr. Arjun was required to submit his nomination paper on before one particular day. He submitted on last date of the, as per the calendar of events, his nomination paper, and he was supposed to submit his papers on the last date before 3 p.m. And it is his further contention that he submitted after 3 p.m. at 3 p.m. 19 minutes. For that reason, his relief was that declare his nomination papers are bad and consequently declare his election is bad in law. Then Bombay High Court declared that his nominations is not proper because after the period specified for submission of the nomination paper, he had submitted his nomination paper. Therefore, his declaration is improper. That is the order which was passed. Then the Arjun Pandit Rao Kotkar approached the Supreme Court. He preferred an appeal before the Supreme Court, and his contention before the Supreme Court that the 65B certificate filed by the returning officer is not proper. She had filed affidavit in 2 lines. That is the reason why there is a standardization, dedicated format has been given. Then the Supreme Court considered that particular affidavit and also consider from whose custody it has been produced, whether it has emanated from the proper custody. Then the court came to a conclusion that she was having the custody and from her custody it has emanated. Along with that particular the electronic record, she has filed 65B certificate and we receive it as it is and we appreciate that particular evidence. Then accordingly, Arjun Pandit Rao Kotkar's appeal was dismissed. The judgment passed by the High Court of Bombay was confirmed. What I am trying to explain is that the 65B certificate is very important. There are so many observations have been made by the Supreme Court regarding the secondary electronic evidence as well as primary electronic evidence. Then what is the importance of electronic evidence has been explained. If it emanates from the proper custody, how it has to be viewed has been explained. How the cases has to be decided has been explained. Then there is a supplementary judgment. That particular judgment passed by the another judge supporting the majority view is also very interesting. I request you all, after reading this particular new legislation, read that particular Arjun Pandit Rao Kotkar's judgment, then it would become easier to appreciate these new provisions. It is left to your discretion. Whatever the judgment earlier to the Pandit Rao Arjun Kotkar's judgment, we should not give much credence to that because Pandit Rao Kotkar's judgment is the latest one. It is passed by the 3 judges and we need to give more credence. Till this particular law which is now introduced further develops, there is a judicial interpretation. We have to refer this Arjun Pandit Rao Kotkar to have a better idea about the electronic evidence. The last statement which I want to make is, in the state of Punjab versus Amritsar Beverages Limited in the year 2006, the Supreme Court had an opportunity to consider the constitutional law as well as the Evidence Act. The statement of the Supreme Court reads as under, a creative interpretation is necessary to enable the judiciary to respond to the development of technologies. This is the development of technology. And we need to give a creative interpretation. The judges are required to give a creative interpretation. Court shall use its own interpretive principle having regard to the developments in the field of science. So the change in the science has to be taken care of. What was law in the year 1950 might have become redundant. That aspect we need to understand. Further, Evidence Act is a part of procedural laws. A creative interpretation is possible in accordance with the circumstances. So they compared the Evidence Act with the constitutional law. The constitutional law also requires a creative interpretation. Similarly, even the Indian Evidence Act demands a creative interpretation. So if there is a creative interpretation within the framework of law, and then if we start deciding the cases, if you people start deciding the cases, definitely I feel that there will be a proper dispensation of justice. My last statement, which I have borrowed from the Delhi Judicial Academy, every trial is a voyage of discovery in which truth is the quest and technology helps to reach the truth. ಸೊ ಸತ್ಯ ಅನ್ವೇಷಣೆಯಲ್ಲಿ ನೀವೇ ಮುಖ್ಯ ಪಾತ್ರ ವಹಿಸ್ತೀರಾ. ಈ ಸತ್ಯ ಅನ್ವೇಷಣೆಯಲ್ಲಿ ಟೆಕ್ನಾಲಜಿ ನಿಮ್ಮ ಒಂದು ಸಹಾಯಕ್ಕೆ ಬಂದೇ ಬರುತ್ತೆ ಅಂತ ನನ್ನ ನಂಬಿಕೆ. ಟೆಕ್ನಾಲಜಿನೇ ತೊಂದರೆಗಳನ್ನು ಕೊಡುತ್ತೆ, ಆ ಟೆಕ್ನಾಲಜಿನೇ ಸೊಲ್ಯೂಷನ್ಗಳನ್ನು ಕೊಡುತ್ತೆ ಅಂತ ಹೇಳಿ ನನಗೊಂದು ಅವಕಾಶ ಮಾಡಿಕೊಟ್ಟಿರೋದಕ್ಕೆ ನಿಮಗೆಲ್ಲರಿಗೂ ಧನ್ಯವಾದಗಳು. ಸರ್. ಎಸ್ ಸರ್. Yes, sir. The blockchain system, the new 65B, as well as the illustration, if we understand, the blockchain system also has been recognized. For example, on a pilot basis, the notary, digital notary has been introduced in one state in India. So entire notarization has to be electronically recorded. And that electronically recorded notarization has to be uploaded to a dedicated server with following a encryption. No, I will. Sir, what I have understood, I will try to explain. That particular blockchain, what is carried out, what is notarization has been done. There will be a dedicated number. There will be a dedicated electronic generated language will be available. That particular language has to be mentioned at the end of the digital certificate. Once that particular digital certificate with that particular electronically generated language is available, when that particular digitalized notarized document is produced, by clicking that particular language, one can view how that particular, who has certified that document, how digital certificate has been issued, at what time it has been executed, how it has been executed. It is an organized sector. Correct, sir. Yes, sir. Correct, sir. Correct, sir. Whereas here, sir, it is traceable because that particular person who is issuing the certificate is a person who has been provided with particular encrypted password. And he is a recognized person. And he is recognized under one particular legislation who is also an officer of the court. So such type of blockchain system will be generated. For example, if I want to adduce evidence sitting in Andaman Nicobar, then there is a possibility of introducing a blockchain system. For that reason, there is a need to make the certain changes in the criminal rules of practice also. More particularly, committees are required to be constituted. For example, some of the committees have been, Shri Alwaji informed me that already the Tamil Nadu state has constituted a committee to understand these changes, to introduce new concept, to make certain changes, to frame additional rules. So, of course, this is first time they have introduced the law. Ultimately, you people have to understand this particular law. You have to explain what are the difficulties you are facing. and how it has to be understood. For example, I have understood the schedule, part A of the schedule, that is with respect of the certificate under 65B, under the old act. But even today, I don't know what is hash value, how to generate the hash value. But my colleague Damodar, immediately he generates the hash value and then he gives it to me. And there is a software, free software is available. So it will take some time, but it is not foreign to us. Easily we can understand it, the blockchain concept and all those things. Thank you, sir. Thank you. Sir. ಹಾಂ ಸರ್, ಹೌದು ಸರ್. ಸರ್ ಈಗ ನನ್ನ ಮೊಬೈಲಿಂದ ನಾನು ನನ್ನ ಕಲೀಗ್ ಮೊಬೈಲಿಗೆ ನಾನು ಕಳಿಸಿದ್ದೀನಿ, ಅದು ವಿಡಿಯೋಗೆ ಮಾತ್ರ. ಅವರು ಅದನ್ನ ಪ್ರಾಪರ್ ಕಸ್ಟಡಿ, ಅವ್ರ ಕಸ್ಟಡಿಯಿಂದ ಕೋರ್ಟ್ ಮುಂದೆ ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡ್ತಾ ಇದ್ದಾರೆ ವಿತ್ ಡಿವೈಸ್, ದೆನ್ ಇಟ್ ವಿಲ್ ಬಿಕಮ್ ಎ ಪ್ರೈಮರಿ ಎವಿಡೆನ್ಸ್. ಹಿ ಇಸ್ ನಾಟ್ ರಿಕ್ವೈರ್ಡ್ ಟು ಫೈಲ್ ಎ 65B ಸರ್ಟಿಫಿಕೇಟ್. ಸೊ ದಟ್ ಈಸ್ ದ ಕಾನ್ಸೆಪ್ಟ್ ಸರ್.
ಅದೇ ನಿಮ್ಮ ಮೊಬೈಲ್ನಲ್ಲಿ ಇದ್ದಿದ್ದು ಫಸ್ಟ್ ಇರುತ್ತೆ, ಟ್ರಾನ್ಸ್ಫರ್ ಆಗಿ ನಮ್ಮ ಮೊಬೈಲಿಗೆ ಬರುತ್ತೆ, ನಾವು ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡ್ತೀವಿ, ಅದು ಪ್ರಾಪರ್ ಕಸ್ಟಡಿ.
ಎಸ್ ಸರ್, ಬಟ್ ಇಟ್ ಈಸ್ ರಿಸ್ಟ್ರಿಕ್ಟೆಡ್ ಓನ್ಲಿ ಟು ದ ವಿಡಿಯೋ. ಇಟ್ ಈಸ್ ಓನ್ಲಿ ರಿಸ್ಟ್ರಿಕ್ಟೆಡ್ ಟು ದ ವಿಡಿಯೋ.
ಥ್ಯಾಂಕ್ ಯು ಸರ್.
ಥ್ಯಾಂಕ್ ಯು ಸರ್. ಥ್ಯಾಂಕ್ ಯು. ನಮಸ್ಕಾರ ಸರ್. ಸೊ ಎಲ್ರಿಗೂ ಧನ್ಯವಾದಗಳು, ನಂಗೊಂದು ಅವಕಾಶ ಮಾಡಿಕೊಟ್ಟಿದ್ದಕ್ಕೆ, ನಿಮ್ಮ ಜೊತೆಗೆ ಮಾತಾಡೋದಕ್ಕೆ. ಥ್ಯಾಂಕ್ಸ್ ಮೇಡಮ್.
Thank you so much, sir. The session was truly comprehensive and insightful. We would be failing in our duty if we fail to place before you all that sir, despite his busy schedule of advocacy, has graciously took time to share his expertise over the subject, over the Bharatiya Sakshya Adhiniyama with us. And sir stood as backbone to the academy to engage classes on Bharatiya Sakshya Adhiniyama to almost all the 18 batches. Once again, on behalf of Karnataka Judicial Academy and all the respected officers present here, I extend my sincere thanks to sir and also to the team for being an integral part of this journey. Thank you, sir. We will have tea break now and we will resume sharp at 12 noon for the next session.